I want to talk to you about common misconceptions about jury trials in Missouri. And some of these things are patently unfair, and they exist, and most people don't know them. So I'm just going to tell you what they are. First, a person runs into you, and they have insurance, and the law in Missouri is that everyone has insurance. Or maybe they don't have insurance, and you're suing what's called your uninsured motorist coverage. The fact that there is insurance anywhere in the case is not admissible. We don't get to tell the jury that the person that ran into you, this nice person in most cases, is not paying. It's their insurance company. That's grounds for a mistrial. So during voir dire, which is jury selection, we get to ask one question about insurance. We get to say, do you or anyone in your immediate family work for Allstate Insurance Company? And that question needs to be approved by the judge. It's got to be sandwiched between two neutral questions. So insurance doesn't come in Missouri. That's unfair. And I'm speaking to you about these things about jury trials because just this week we concluded a jury trial in Columbia, Missouri. And so the next thing I'm going to talk to you about, and that was my law partner, Brian Winebright. And Brian's brilliant. He's a genius. This is a picture of Brian from a few years ago. We're going to put on the screen when we put his name on the door, and it was just he and I. And that's why Brian is my partner, along with Kevin Glenn, because they're brilliant. So the number two thing is venue. That's where the case is tried. There's a lot of advertising right now about bigger being better, and that's bullshit. That's not the way it works. Bigger is not better in Missouri. Being present is better. Having a lawyer that will actually go to a jury trial, like Brian did this week, and get triple the amount that was offered by the insurance company. That's better. Better is having a local attorney and a local law firm that knows the jury pool. So, venue. In Missouri, we say that in the city of St. Louis, people give away other people's money, and in the county, they give away their own money. The county tends to be very, very conservative about giving away money, whereas the city does it more freely. So that's why we have all these venue laws in Missouri about where you can actually file that lawsuit and proceed, and those laws were changed. But essentially, it's where the accident occurred. So venue is very, very important in Missouri. The third thing is subrogation. Subrogation is a foreign concept to most people, but it's an insurance word. It means that insurance companies get their money back. So your health insurance pays after you get hit in a car accident. Let's say your health insurance gets billed $100,000 and they pay out $30,000. When you win that case, if Cantor Injury Law represents you, and let's say we win $1 million, we've got to pay back the health insurance. That's called subrogation. It seems unfair. That's why you have a health insurance. But all these health insurance companies have lobbied big government and big business so that they get their money back. That's what insurance does. They accept premiums and they don't pay benefits. And when you do win benefits from someone else, they want their money back. That's called subrogation. Number four, there's not an absolute right to a jury trial in Missouri. Not in a civil case where you're asking for money. That's not an absolute right. I'm going to give you some examples. But you have that right in criminal cases. You don't have it in injury cases. And the biggest example of that is Missouri workers' compensation. If you're injured on the job, you don't have a right to a jury trial. It's an administrative law court. You go in front of that judge. And that's it. And if you're a borrowed servant, you don't have a third-party lawsuit. You don't have a right to a jury trial. So if you work for one employer and they lend you out to another, and you have a terrible injury with devastating injuries, and if there's no third-party liability, like getting hit by a pickup truck that's owned by someone else, you don't have a civil case. You don't get to sue for pain and suffering. You just get a judge. There's not a right to a jury trial there. Number five, evidence of your bills for all your treatment may not come in. In Missouri, we do a billed versus paid analysis for which bills, what the jury gets to see is the value of your medical care. And that's a big fight in every single case, because in the example I gave you previously in subrogation, your insurance company may have been billed $100,000. We want to show that jury $100,000, but they only paid $30,000. And the defense wants to show that jury $30,000. And that changes because, a jury might give $500,000 if they think the bills were $100,000, and they might give, $120,000 if they think the bills were $30,000. So there's a big fight. You need a local lawyer that knows that fight to do the billed versus paid analysis. The entire amount of a lien for medical care comes in. So at Cantor Injury Law, many of our patients, our clients, treat with medical providers that keep a lien. So then we negotiate after the case is resolved about what the true value of that bill is. So when we go to trial, we get to show the entire billed or liened amount. So the evidence of your medical bills does not come into evidence unless you do it right. Remember how I told you, this is number 6, remember how I told you that the insurance industry has affected this business tremendously. They have a right to get their money back. But guess what? You don't have a right to get paid in every case. Because if the defendant did whatever they did on purpose, so if they punched you, that's not a negligent, that is an intentional tort, and that's not dischargeable in bankruptcy. So if they punch you, they can't discharge it in bankruptcy. But if they hit you with their car accidentally and they don't have insurance, that's a negligent tort. And negligent torts in Missouri are dischargeable in bankruptcy. So if someone did something on accident and they don't have any insurance, they may not have to pay you if they file for bankruptcy. Here's another, number 7. Subsequent remedial measures are not admissible in Missouri. Now, there are certain exceptions, but I'll just give you a simple example. If there's a big hole and you fall in it and you break your arm, and the next day the person that created that hole fills it in, you don't get to go to trial and say, hey, they filled in the hole. That's called a subsequent remedial measure. Now, there are certain tricks to get that in. If you've got a smart lawyer, you can say, is there anything that you could have done to prevent this from occurring? And if they say no, then maybe you can bring in that evidence that they filled in the hole the next day. But as a general rule, subsequent remedial measures are not admissible at trial in Missouri. Here's another basic one, burden of proof. Criminal cases, you got to prove it by beyond a reasonable doubt. In Missouri, it's a preponderance of the evidence. So we only have to prove by, more likely than not that the defendant caused your injury, your harms, and your losses. So it's an easier burden. But in Missouri, you won't necessarily have a completely non-biased jury pool. If a juror says that they're not inclined to give financial damages, you'd say, well, they're biased. But if they agree that they're willing to follow Missouri law, the judge is probably going to keep them on that panel. So you may have a group of, this goes back to venue, you may have a group of people that are just unfavorable. They just don't want to give any money for injuries, ever. But if they agree to follow the law in Missouri, the judge is going to keep them on there. You only get a certain amount of strikes in Missouri, called preemptory strikes. You can use them for whatever reason you want. Once those are gone, you're done. So you might have a very bad or very biased jury pool. That's why venue is so important. Here's something that may be favorable if you're the injured person. We just gave a young person hundreds of thousands of dollars. That money is not taxed. Personal injury money does not have tax. Lost wages, though, do have tax. So if we're recovering $1 million for someone, if $900,000 of it is for lost wages, they're going to get hit with a tax bill. They're going to have to pay half of that in tax. So we call every settlement cases. Every settlement case is for pain and suffering, which is not taxed. So that was number 10. So the point is, If you have an injury in Missouri, there's a lot of things you need to know about jury trials. We know them. I know them. I've been doing this for 30 years. Jury trials are back. Brian Winebright, my partner, one of my partners, had a jury trial this week, as I told you, in Columbia, Missouri. I can go into each one of these things ad nauseum in depth. Actually, I taught law as a professor at Harris Stowe State University. I'm sure I bored those kids to death. But the point is that when you're injured, you want to have a lawyer that knows the law and knows how to apply the law in front of a jury in Missouri. The case that Brian tried had two other law firms before us. They had the case for years and years and years. That case was 8 years old. Brian did a great job. He did not admit into trial the amount of the past bills because they were low, and the jury awarded over 3 times the amount that was offered. So that's a great job for my partner. So congratulations to Brian on going to a tough venue and getting a great verdict for a deserving client. And so if you ever need a lawyer, please call Cantor Injury Law, 314-628-9999. Thanks for watching.